Good morning. Hi, everyone. I'm Tony Veroven, Exchange Community Manager at CSIA. Thank you for attending this month's CSIA webinar. Today, attorney Mark Voigtmann will present indemnification, how to keep calm when the I word appears. A reminder that if you have questions for our speaker, please use the Q&A box to the right of your screen, not the chat box. This program, like many of CSIA's webinars, will be archived on controlsys.org, typically within 24 hours of the broadcast. Many thanks to John Weber, Monica Anderson, and the whole team at Software Toolbox for hosting and sponsoring our monthly webinars like this. Software Toolbox was created in 1996 to rid the industry of bad third-party software experiences. They do this by providing a single contact source for a variety of industrial automation software tools and applications, the knowledge of how they work together or with other automation software to deliver end-user value, and a responsive, proven support process, all focused on lowering risk. Looking for solutions? Find them on the web at softwaretoolbox.com. Today's presenter, Mark Voigtmann, is a partner at Faegre Baker Daniels. He has been active with CSIA for several years, attending and speaking at our executive conference on a nearly annual basis. At this year's conference, both Mark and his colleague, Brian Clifford, will present sessions on managing legal risk and dealing with conflicts in customer terms and conditions. You can read more about these and all conference sessions at CSIAexecutiveconference.org. Please welcome Mark Voigtmann.
Thank you very much, Tony. Good to be here. I know many of you, some of you are new to me. The I word. You should be keeping calm, but you should be alert about this word when it appears. And I am, as Tony mentioned, the lawyer for the CSIA. I wrote a book on automation called The Automation Legal Reference, and I am the person behind the CSIA legal plan, which is being offered in its first year for CSIA members. The I word is indemnify, indemnity, and indemnification. All of those words appear usually deep inside of a contract, sometimes as a standalone agreement called an indemnity agreement. There are other words that go along with it. You will typically see hold harmless, defend, and some of the other ones, to the extent caused by, from and against, to the fullest extent permitted by law, and others that keep lawyers fully employed. When we're talking about indemnity agreements, we're talking about a two-party agreement regarding a third party.
Good morning.
You typically sign a contract between two parties. The third party is what the indemnity agreement is about. So a two-party agreement about what? It's about what happens when a third party makes a claim. That's what most indemnity portions of a contract relate to. What kind of claim? Well, all kinds of claims. A personal injury, property damage, it can be breach of contract, it could be patent infringement, it could be liens, or really anything that a third party brings in the way of a claim. As an example, let's say that an integrator indemnifies an end user, the company. So as an example, the third-party worker is injured, sues the end user. If there is indemnity, the integrator takes responsibility. But there are a number of variables. What is the process for making a claim? How do you get that indemnity once it's given? Does the claim need to be caused by the person giving the indemnity? Is the person making the claim covered by the agreement? What kind of responsibility is owed? What if the person receiving the indemnity contributed to the injury? Is the indemnity covered by insurance? Those are all of the things that make indemnity clauses or indemnification clauses complicated. So let's talk about some of the types of responsibilities. When the words hold harmless appear in an indemnity paragraph in a contract, this is a promise by you, the integrator, not to sue the other person, not to sue you for the injury. So you've got a claim from a third party. It's made against the integrator, and with a hold harmless part of an indemnity agreement, you are promising not to sue the company when you get sued. That's the first part of the mix of indemnity obligations. The actual indemnify part is a promise to reimburse you, you being the other side that you're making the contract with, for any damages that party must pay. So if there was a claim against the company that you did the indemnity agreement, that you're indemnifying, you pay for the damages that the company must pay. That's what the meaning of indemnification is. If it's a defend obligation, if you agree to defend, you are promising to hire lawyers to defend you, being the company. So if there's a claim against the company, you would hire lawyers to defend the company. And often these agreements are all combined into one: hold harmless, indemnify, and defend. So at the bottom you see that there is a claim made both against the company and you. So once you get the claim, you're not going to make one against the company that you indemnified because you held them harmless. Because you're defending them, you're going to pay any loss and hire lawyers, and because you're indemnifying them. That's the meaning of those three together. So what does that look like? It looks simply like this. Integrator agrees to hold harmless, indemnify, and defend company from and against any and all losses, including attorney's fees, suffered in connection with the project, something like that. But that's a very simple version of it. It can be a lot more complicated. For instance, it's really never that simple. There could be language like this: the integrator for itself and its parents, subsidiaries, affiliates, principals, and partners. So in this indemnity agreement, the integrator is speaking not just for itself, but a whole variety of other companies and affiliated companies which it's associated with. Or we could expand who it is that's being indemnified. The company, not just the company, but also its parents, subsidiaries, affiliates, officers, employees, and partners. So you've expanded the group that you're protecting. Or it could even be beyond the company entirely to other companies that are involved, not just the company, but also the independent engineer, the general contractor, and all of their various affiliates. So the indemnity might be extended way beyond the company that you have a contract with. Or you could expand the costs that are being indemnified against. So not just their losses or attorney's fees. Losses would be the indemnity portion, the attorney's fees is the defense portion, but also their expert costs, their lost business opportunities, and other downstream effects could be expanded. So how do you keep calm and carry on when the I word appears? What's the way to approach these paragraphs? Here's my set of recommendations. First, well, you simply work the problem. And number one on the list is analyze the types of claims that are included. I say that it's okay to indemnify and defend and hold harmless with regard to personal injury and property damage. The reason is those things are the subject of the insurance that you have likely purchased. What's not okay is to indemnify for claims for economic loss, like the fact that some third party did not get the profit that they hoped to get on this project because of your actions or because of the end user's actions, and they're making a claim for economic loss. Well, that's not insured, and you're taking on someone else's protection that you don't have insurance for. Also, two-party contract claims. You may be indemnifying for your own breach of contract or the other side's breach of contract, causing a third-party claim, and those things ought not to be dealt with in the indemnity relationship. Now, I call liens and patent infringement as sort of an in-between character. They're not great to indemnify for because you don't have insurance for liens, and we're talking about third-party liens. Some other party files a lien because of something you did, or even just something related to the project. Or your software infringes on someone else's patent. Let me just stop some. There we go. It is reasonable for a company end user to expect that your software does not infringe on someone else's patent. And even though you don't have insurance for it, it's hard to get out of it. So that's why I put it in between. The second thing you should do is analyze the cause trigger. If the indemnity clause says, to the extent caused by you, meaning you, the integrator, that's okay, because you have control over the things that may trigger that indemnity. Not okay is even if it's caused solely by the other company, by the end user that you are contracting with, it's not cool, it's not fair for you to indemnify for their fault. In between is, even if it was caused partially by the other company, you are indemnifying for all of it. That's to be avoided if possible, but it is typical. (2A) on the working the problem is analyzing the arising from trigger. There can be the words arising from in the indemnity provision, and here we are talking about arising from your work as being something that is natural for you to indemnify for. Less desirable is arising from the project, because that's not just your work, it could be anybody's work, and you don't want to indemnify for that. You should analyze who is being protected as a third step. It's okay to indemnify the other company and all of its people. It's not desirable, although it's sometimes done, if you are going to be indemnifying additional players, like the engineer or the architect, or additional companies that you don't have a contract with. You should, fourth, analyze who is giving the protection. It's best if it's just your company that is doing it. It's not okay for individuals associated with your company to be listed in the indemnity provision, as sometimes is the case. It would say, on behalf of XYZ company plus its principals, its owners, which is an argument that your corporate entity is to be disregarded and you, an individual, are giving an indemnity to the end user. It's okay, if necessary, to put in affiliates of your company if you have more than one company. Fifth, you want to analyze the type of protection being offered. The best is just a home harmless, that you will not seek a claim against the end user for third-party claims. Indemnity itself is okay if necessary, and least desirable is to defend, because that is the most expensive. You want to analyze any limitation on damages. It's best for there to be a hard limit. It does not have to appear in the indemnity clause itself. It could be in a different part of the contract. It's okay to get a waiver of consequential damages. The difference between a hard limit is like a dollar figure that applies to as an upper ceiling on damages. A waiver of consequential damages is taking out a category of damages that is likely to be high. Lost profits of the facility, for instance, that you're doing your work in. Not okay is it for there to be no limit, but it's often the case, as I suggested, for there to be no limit in the indemnity clause itself, but for that to appear in a different part of the contract. You want to analyze the process that's contained in the indemnity clause. The best is to see a strict notice deadline, because you want there to be only a narrow window for the person giving indemnity, requiring an indemnity from you to give you notice that there is a claim that you are indemnifying for. Better is that there some notice is required, although there's not strict deadlines, and no notice at all is the least desirable. Here are a few finer points on the problem. What is covered by your insurance? Personal injury and property damage are typically covered. Breach of contract might be covered if there's sort of an allegation of professional liability and you have professional liability coverage, or if there's an element which could be claimed to be property damage. Patent infringement typically is not covered by your insurance, and liens are typically not covered. But as I mentioned, it's hard to get away from some indemnity for patent infringement. What are the rules for providing a defense is something that, if you are in a mode where defense must be provided, it's best that the attorneys are hired at your cost, because that's what defense means, but also under your control. Not okay is if the defense that you are providing is their choice of attorneys, hired at your cost and under the other side's control. Obviously, it's best not to let the attorneys wander off and spend as much as they can in defending at your cost for obvious reasons. In oil and gas contracts in the United States in particular, there is something called knock for knock indemnity, which is very much different than what we've previously been talking about. And the reason for that is oil and gas facilities have a higher risk of injuries and property damage happening. And for that reason, this tradition has arisen where everybody agrees to pay for injuries and damage affecting themselves regardless of cause. So if any of your workers or any of your property is damaged regardless of who caused it in a knock-for-knock indemnity provision, you will handle paying for that cost. And so will the other side. Even if you cause damage to the other side, they will pay for those damages in a knock-for-knock indemnity. We have a question. If an end user specifies system IP designs and the integrator implements it as such, but it conflicts with a third-party patent or IP, who is at fault in the claim? Well, that doesn't really speak about indemnity. That just speaks about who ultimately would be held responsible. Let's say that there is, though, an indemnity that covers IP. The third party sues as a result of that infringement, and then you are supposed to indemnify the end user against that IP infraction that the end user caused. Well, that goes back to, are you indemnifying them for their own fault, or is there a fault-based trigger to you? So really, the critical factor in that problem is the fault question. In other words, if you're indemnifying for their fault, which is illegal in many states, you would still be on the hook for their problem. Reciprocal indemnity is another issue. Here we see a typical integrator agreeing to hold harmless, indemnify, and defend the company from and against any and all losses, and it has been crossed out to make it reciprocal. This is one way of doing it. You simply change out the word integrator and company for each of the parties agrees to hold harmless, indemnify, and defend each other. The other way is to make it reciprocal by adding something at the end that's really simple, like company likewise agrees to provide the same indemnity protections to integrator in a fully reciprocal way. And I mentioned that there are some anti-indemnity laws. Remember when I said work the problem by analyzing the cause trigger, and that it's okay if the cause was to the extent caused by you, and it was acceptable even if it was caused partially by the other company? Well, in many states and in some countries, even if caused solely by the other company, is prohibited. It's against the law to have a provision like that kind. So even if you don't cut it out, there might be a law in the state where you're doing your work that cuts out that kind of provision, where it's only their fault and you're still indemnifying them, kind of like the IP example that we just talked about. We have a question, do you have any negotiation recommendations to get better terms for ourselves if we deal with buyers or lawyers? I'm speaking more to communication tactics, looking to win-win versus the technical elements of the negotiation. Well, I think the best tactic that you can have is to speak to the issue of control of risk. In other words, if they're asking you to make payments to them or to protect them for risks that are not under your control, that is not fair. And it's a bedrock principle that lawyers understand and that buyers understand, that a person should only be given the risk that he has some impact on. Otherwise, there's no way of working it. The other thing that can be used for negotiations is the idea of the cap on a risk. It is a common sense argument to make to say to the other side, look, you're not agreeing to any cap here. Are you expecting me to put my entire company on the line for every project that I do? That's the best argument to unlimited liability and would be the argument for either a waiver of consequential damages or a hard limit cap on the damages that you have. And keep in mind, even if all of the worst examples of doing things that I've given you, where I've given you okay, in between, not okay, even if all the not okays were in place, if you've got a hard limit on damages and or a waiver of consequential damages, which is the biggest and worst category, it doesn't matter as much that you have some of the non-recommended or not okay indemnity features. Details matter. There's a lot of details that come into play in these things. It's possible to define expenses. This is an actual indemnity provision. It defines all of the expenses. And it goes on, and this is not the end of it. Exclusivity is a typical detail that makes it more complicated. The indemnity is not the only remedy. There could be other remedies. Sometimes it is an exclusive remedy. The question is being asked, at what level do you begin a cap? Well, I usually suggest beginning at the amount of the contract in question. In other words, if you've got a proposal and a purchase order for a particular project or a contract for a particular project, then you say that the damages cap is that amount. Now, that usually won't fly because it can be a pretty small number. So there are different ways you can go after that. The backup position might be all amounts paid to your company in the past year would be the cap. Or you could say a multiple of the amount that you're being paid for this contract, like 3 times the amount or 2 times the amount. Or it could be the total of 2 years of all the amounts that you've been paid. The question has been asked, when a clause specifies that the company selects the defense and retains control of the defense and settlement, is this covered by the integrator's insurance policy? In this particular person's case, they are using the CSIA insurance program. It might not be. It might not be covered, so that's one of the dangers of agreeing to that. Chances are it would be covered because there are flexibilities built into the CSIA program. I just happen to know that because I'm often hired myself to be the defense counsel by the CSIA program. But that is a danger that you're getting into if the company has the right to select the defense and retains control of the defense because your insurance company wants itself to have control. That puts you in a very bad situation, and your argument to them would be, look, I've got insurance here and we want it to apply, so you would want to say subject to anything contrary in the insurance. And we talked about notice a little bit. That also can be very complicated and and there should be provisions there that are that make it more difficult for your indemnitor or the indemnity, I should say, making a claim against you. We're near the end, so I thought this is the small ad portion. Look up the fagrebd.com CSIA Legal Plan website. I thought I'd point out 3 hidden gems that not enough CSIA members know about and are taking advantage of, and that is the free, depending on whether you're certified or not, or $250 updating of T's and C's, which is nearly free. There's a yearly amount of money you can pay for an unlimited basic risk assessment, and even for all legal services associated with contract revision services on a yearly basis, $15,000 for certified members. So are there any other questions that anyone has? We are at the end of our half hour. Well, if you have any questions going forward, be sure to send them to my email address. Feel free to do so afterwards or call me. I should also mention, though, I less like to mention this one because it's utterly free. We have a policy of 30-minute free consultations just to answer simple questions. So there's also that available for. And there's a question that's been asked as to whether, let's see, I couldn't quite pull it up. And there was a chat that came in and I did not get it. Oh, can a company be indemnified for their own gross negligence? Is that enforceable? I don't think it is, to the person who asked that question. Gross negligence, their own wrongdoing, that's what I would call an illegal contract, and I think would be prohibited in every state and most countries. And there's one more question. What about limiting the indemnity to the limits of the insurance policies? Yes, that is a very good strategy to say to the extent covered by insurance, and that's something that I often do. And we had, what was the cost for non-certified members on the previous screen? Let's see if I can go back one. You see that at the bottom, actually. So for non-certified members, $250 for updating their T's and C's, $6,500 for non-certified members that's a flat fee for the whole year of unlimited basic risk assessments, and it's $20 grand for non-certified members for unlimited contract revision services. So, and can you go over the 15,000K offering again? That means you spend $15,000 at the beginning of the year if you're certified, and we do all of the contract revision that you need, all that you need for the entire year period. And you're never charged again unless, you know, disputes and things like that that are not included. All right, let's see if there's any other questions. If the contract is silent on consequential damages, it doesn't exclude them, or it doesn't include or exclude them, should you argue to exclude them? Yes, if a contract is silent on consequential damages, that means that they're in almost all cases. In other words, you don't mention what damages there are, then they can make any claim that they want, including a claim for consequential damages, which are everything from lost profits to incidental costs, lost opportunities, you name it, it's out there. I believe that that's the end of the road on questions, and we're at the end of our 30 minutes. So, Tony, I'm going to turn it back over to you.
Thanks, Mark. Thanks for helping everybody understand or translate that fine print. And thanks, everyone, for your participation in today's program. Note that the full webinar will be archived on controlsys.org within the next day or so. Many thanks to our host and sponsor, Software Toolbox. Thanks, Monica and John. Find them on the web at softwaretoolbox.com. Very shortly, you'll receive a 30-second evaluation about today's program. Your feedback is valuable to us, so we ask that you please do complete it. Lastly, if you have not done so already, I encourage you to register for the 2017 CSIA Executive Conference, May 2nd through the 5th, where Mark will be one of our presenters. Incidentally, March 31st is the final day for early bird pricing, so check out CSIAExecutiveConference.org for all details and to register. This is Tony Verhoeven at CSIA. Thanks for attending. Goodbye.